Okay, thanks, Gloria. Good afternoon, ladies and gentlemen, and welcome to our session number 5 in the Know Your Tribunals series. First of all, my name is Helen Namisi, and I'm the Vice Chair of the LSK Nairobi branch. And the LSK Nairobi branch is mandated to look into practice and welfare matters for advocates who are practicing in Nairobi and Kiambu counties. And so to this end, we have organized this series to ensure that practitioners as well as the general public are conversant or aware of the various tribunals that exist in this country and are able to utilize the same for redress for whatever grievances they may have. So on behalf of our chair, Eric Theory, and the branch, I welcome you to our session today. It's the penultimate session. Next week will be our final session. This afternoon, we are privileged to have 3 very interesting gentlemen. We have Dr. Njaramba Gishuki, who is the chair, and I'm going to say this slowly because it is a mouthful, of the National Civil Aviation Administrative Review Tribunal. We also have Professor Kiare Mwaura, who is a member of the Transport Licensing Appeals Tribunal Board, TLAB. This is a very interesting one. And we have Daniel Ogola, who is the chairperson of the Competition Tribunal. So I welcome all of you. Sit back, relax, listen to this enlightening discussion we're going to have this afternoon. Learn something about these tribunals. For the lawyers, this is an opportunity for you to actually find another area of practice other than what we know, and explore the various opportunities out there. I want to invite participants to write their questions in the chat section. We will have a Q&A session after the presentations, and please do use the chat section. Write out your questions. They will be addressed thereafter. So to set the ball rolling, I want to ask Dr. Gishuki, tell us, this mouthful of a tribunal, what is it about? Is it just aeroplanes, Wilson Airport? That's what we think about when we hear civil aviation.
Good afternoon, and thank you, Helen. Now, the National Civil Aviation Administrative Review Tribunal is a tribunal that basically deals with civil aviation matters. By civil aviation matters, here we are talking about any person who is a licensee of the Kenya Civil Aviation Authority can bring matters to the tribunal. That includes pilots and the airlines. And on the other hand, it also deals with matters of consumer matters. That is matters between consumers of airlines, and therefore they can also bring matters before the tribunal. And therefore the parties before tribunals are basically consumers, airlines, and then KCAA on the one hand, and the licensees on the other. That is what it deals with.
Right. I'm just curious, when we say consumers, are we talking about passengers or are we talking about the airlines? Can I, as a passenger, come to the tribunal?
Yes, that is so. When we talk about consumer matters, we are talking about a person who, for example, was supposed to travel from Nairobi to Kisumu by air. And then either he is delayed, for instance, for an hour for no good reason, or his luggage gets lost, or we are also talking about you paid for a flight, but then somehow the flight didn't happen. And therefore, all consumer interests are supposed to be, they are brought to the tribunal, and therefore the tribunal is supposed to deal with all those matters for the benefit of consumers.
Wow, thank you, Dr. Actually, I wish I had known about this tribunal before. Very interesting that passengers can actually come to this tribunal to seek redress. Let's move on to Professor Mwaura, Transport Licensing Appeals Board. You know, when we hear about this one, we just know matatus. Is it only matatus that you deal with, or do you deal with us common mwananchi? Do I have to have a PSV? Sorry, you're muted. Prof, you're muted.
Thank you so much for that question. Just to say that at the Transport Licensing Appeals Board, we are very happy to be part of this session of today. And we deal with very diverse issues in the transport sector. Our jurisdiction is tied to the NTSA, the National Transport and Safety Authority. So NTSA does two very important things, two important roles. One of them is that any vehicle that is manufactured in Kenya or imported into the country, NTSA registers that vehicle. And then for the public service vehicles, apart from registration, it actually issues a license to carry passengers. So our jurisdiction is tied to the licensing decisions of NTSA. We don't touch the registration, but we only deal with the licensing issues. This is a license that is given to a vehicle to fly, to carry passengers, public service vehicles. This could be a license given to tourist vehicles to carry tourists as well. And also any kind of license that is issued by NTSA, including your personal driving license. Your own personal driving license, you could be applying for a license and you find that the system of NTSA is not working. It is very slow. You're not getting a response from NTSA. You're paid everything. All that delay, as per Article 47 of the Constitution and the Fair Administrative Action Act, they are supposed to provide efficient services. So you can bring a case to say that my application for a license, even the new digital license, it is taking too long and I've done everything on my part, but NTSA is not efficient. You can bring a case to us and we'll listen to it. Apart from the personal licenses, the licenses affecting public service vehicles, the ones affecting the tourist vehicles, there's also another category of licensing which deals with the route licenses. When a matatu is flying, let's say from Nyeri to Nairobi, it is given a license for that route. The license from Nyeri to Nairobi. It cannot go to Nakuru. But if an investor has really done very well in business and their business has grown and they want to be able to extend their route, not only to be reaching Nairobi from Nyeri, but they want to be reaching Nakuru, they go back to NTSA and apply for a route extension. That's a license. So sometimes you find that people apply for that license, it takes too long, or sometimes they're not even given a reason as to why they're not getting the route extension. So they come to us to complain about that as well. As for the public, members of the public as well, you could have competitors in different routes. Let's say that, let's say NTSA has allowed a new entrant into a route. We have seen cases where even border people or the residents come to complain and tell us that that route is too congested. NTSA should not allow another operator there because it is going to create chaos. So any member of the public. So apart from the issuance of a license and the failure to issue a license, one can apply actually to cancel a license of an operator that is given that is not actually following the rules or that is unruly. All those cases come to us. Thank you, Helen.
Thank you, Professor Mora. And just to follow up on that, and I'm asking for a friend, in the event that NTSA, for example, is taking too long to register a transfer of a motor vehicle, is that something I can come to T-Lab for, or it's only licenses?
Thank you. It's something that we are working on. We are working with Parliament to see whether we can actually extend our jurisdiction to cover registration of vehicles. At the moment, we are only tied to licensing.
Okay, thank you very much.
We get a lot of queries from people who have problems with registration. And we are working with Parliament to see whether our jurisdiction can actually be extended to that.
As I said, I'm asking for a friend. Mr. Ogola, now we come to you. This special tribunal called Competition. And again, I'm asking for a friend. When we say competition, do we mean competition between businesses? Me who has my exhibition here and then somebody opens next to me to sell the same thing? Is that the kind of competition we're talking about, or which one?
Thank you, Helen. The Competition Tribunal is basically a commercial appeals court. The tribunal was set up specifically to hear and determine decisions made by an organization called the Competition Authority. The Competition Authority is the regulator of matters that deal with promoting and safeguarding competition in the national economy. The main aim being to protect the public from unfair market prices, unfair, misleading market conduct. The Competition Authority in itself deals with certain aspects of the law, for example, mergers and acquisitions, unfair practices, and basically restrictive trade practices, among others, abuse of dominance, unwarranted economic power, and consumer welfare cases in general. The main aim is to promote and protect consumers from unfair and misleading market practices. That is the Competition Tribunal. So it is an organization or an entity that basically handles appeals from decisions made by the Competition Authority. For example, if you have a stall and you're complaining about your neighbor, you cannot come to the tribunal because the tribunal is specifically set up with a mandate to deal with decisions emanating from the Competition Authority. So basically that is the Competition Tribunal.
Thank you, Mr. Ogola. So just to follow up on that, my previous question where I'm asking for a friend again, if I have my stall and I'm selling my, or we call them boutiques, I have my boutique and I am complaining about my neighbor who is doing something similar, I would first go to the authority, and then if I am aggrieved by their decision is when I come to the tribunal.
Correct. The tribunal, as I mentioned, is an appeals court. The organization or the entity of the first instance would be the authority. Then if you're aggrieved by the decision made by the authority, then you can make an appeal to the Competition Tribunal.
Okay, so in that case, the respondent is almost always the authority.
That is correct.
Okay, great. Back to you, Dr. Gishuki. In your case, is the respondent always civil aviation, or is it, can the respondent be an airline? Can the respondent be, who are the various respondents we can find before your tribunal?
Thank you. Thank you. Now, we have mainly two respondents. Number one, the matters that come before us are either appeals from a decision of the Kenya Civil Aviation Authority, which means that the respondent will be the Kenya Civil Aviation Authority. And this is where we say that it is either it has refused to grant a license, some authorization, and so on, or it has revoked a license, it has suspended one, or it has, for example, imposed some orders on a licensee and so on. So all those decisions are the ones that are brought to us on appeal. And in those cases, it is the Kenya Civil Aviation Authority that is the respondents. However, on the consumer protection matters, you find that the respondents are the airlines. That is to say that someone paid for a ticket for a flight to a certain place and it did not materialize, and therefore he sues the particular airline. And therefore, our respondents are mainly the airline, and are actually the airlines and the Kenya Civil Aviation Authority. Now, of course, everything that is done by the Kenya Civil Aviation Authority in exercise of its powers, it's appealable to us, of course, except those things that relate to the internal matters of the Civil Aviation Authority. But anything else that it does to deal with their licensees is appealable to us.
Thank you very much, Daktari. So still on you, Daktari, tell us, how would one then approach your tribunal? Would it be by way of a plaint? Does it have to have a specific format? Can I just walk in and say, I was supposed to board a flight to Kisumu last week and it did not happen and I am aggrieved. I want you to listen to my case. How do we approach your tribunal?
Thank you, thank you. Now, one thing, Helen, that has happened is that this tribunal hasn't operated for a long time. And what that means is that actually this is the time we are finalizing on the regulations to come and the rules for filing of pleadings and of complaints and appeals at the tribunal. But what we have been doing is that we have basically been using the civil procedure rules for purposes of making appeals and bringing complaints to us. However, what we do is that we actually admit a complaint on in any form. By that meaning that we have seen complainants write a letter. And when a letter is written to us, we admit it and make it a complaint, and then we proceed with it, and therefore we require the respondent to file a response. And therefore, at this point in time, because we haven't yet had our rules gazetted, complaints come in all forms and shapes, and we admit them as complaints. But then, of course, when we are doing applications, of course, we will still take them as notices of motion, especially when counsel are involved. You still find that there are preliminary objections that are filed where counsel is involved. But there is no particular form that we have today that we use pending, of course, now the gazettement of the rules that we are formulating, and which very soon we are going to take out for public participation for purposes of the members of the public to give their input. Thank you.
Thank you, Daktari. Mr. Ogola, now that yours is an appeals tribunal, does it mean then the appeal, or for me to lodge a claim there, it must follow a particular format?
Yes, Helen, thank you for the question. Being an appeal, it means you're appealing against the decision of the competition authority, who are the respondents. You will need to prepare a memorandum of appeal, and the appeal must be accompanied by an affidavit stating the facts why you're appealing, a decision of the authority from which you're making the appeal from, and then you would have your supporting documents, list of documents, exhibits annexed to the affidavit, and you will file it with the tribunal secretariat. The tribunal secretariat is based at Kenya Re Towers in Upper Hill on the 10th floor. And we encourage parties, because of COVID protocols, to file both hard copies and electronic versions of the documents they are filing. So yes, how you approach the tribunal is by a way of a memorandum of appeal. And once the appeal is received by the secretariat, they will then serve it upon the respondent, who's the competition authority, to respond to your appeal against their decision.
Oh, that's very interesting. So I, as the applicant, do not need to serve the respondent. You will do it for me.
Yes, once the appeal is filed with the secretariat then prepares a summon to the respondent, notifying them of the appeal and requesting them to respond to it.
Wow, thank you very much. Professor Maura, for TLAB, is there a particular way that we must approach the board, or can we come by way of a letter, as is the case with the National Civil Aviation?
Thank you, Helen. For the Transport Licensing Appeals Board, because of the nature of our tribunal, we deal very much with the informal matatu sector. And because of that, we tend to be very flexible. And the enabling statute, the NTSA Act, actually allows the tribunal to set its own procedures and proceedings. So we have actually used that to our advantage to make sure that we keep things very informal. So even if someone does not file, we usually say that people file a memorandum of appeal, but even if they do a letter on a full scope, or they come to court and complain in person, we take note and we don't dismiss anyone. So we are that inflexible. Because some of the people who are coming to us are the people who are in the matatu sector. This could be the driver, could be the owner, could be the conductors, who are complaining about lack of clearance by NTSA. So we saw that if we keep it very formal, then we are going to shut out very many people. So we keep it fair everything.
So having said that, Professor, does that mean then one does not need to be represented by an advocate at the Transport Licensing Board?
No, actually you don't. A lot of people actually come and they represent themselves. And because of that, you find that they cut down on the cost and everything. And we also try as much as possible, as we are listening to the cases, we actually accommodate them quite a lot in terms of being quite flexible in what we do. And in terms of some of the complaints that we get, you find that there are two main categories of people who come to us. One category is a person who is a licensee of NTSA. That person is either complaining about the failure to act by NTSA. They are saying the NTSA has taken too long. I applied for this driving license, it's not coming through. And so they are complaining at Article 47, the Fair Administrative Action Act. And the second category is an objector, a person who is complaining that a certain operator has been allowed to get into a route. The route is already very congested, those kind of complaints. Or someone complaining that that other operator who has been given a license was given a license when they have not complied with all the regulations of NTSA. And we listen to those kind of cases. So the objector could be anyone, could be a member of the public. And so we keep it fairly informal so that we can hear all the complaints coming to us. Thank you.
Thank you, Professor. Back to you, Mr. Ogola. Now that yours is appeals and it's appeals against the competition authority, it sounds very serious, like somebody should have an advocate there. Is that the case? Can I represent myself? Sorry, you're muted.
The rules of procedure of the tribunal, you can represent yourself or through an authorized representative who need not be an advocate. So you have both the liberty to represent yourself or get an authorized representative to represent you in the matters before the tribunal.
Thank you, Mr. Ogola. Dr. Gishuki, I can only imagine that if I am coming up against an airline and they have a battalion of Ivy League firms on their panel, then I really do need legal representation. Is that the case? Or can I represent myself?
Yes, not necessarily. A person can represent himself or herself. You do not need an advocate to appear before us. Indeed, it's not just individuals. We have seen occasions whereby even airlines or owners of planes actually come without advocates, so that you find the director of let's say a small airline filing the pleadings himself by way of a letter. And therefore, an advocate is not really required as such, but then of course, advocates are allowed to represent clients before us. So it is either an individual to represent herself or to get an advocate.
Thank you, Daktari. Just a reminder to our participants, those who are joining us, Karibuni, please use the chat section to write your questions. We will have a Q&A session after this So please write your questions if you have any for our three presenters. So let me start with Mr. Ogola. The typical question that most people ask in this country is, how long will my case take? Because we have seen cases lasting in court for years and years until generations pass and go. So how long would a matter, on average, take before the Competition Tribunal, on average?
Thank you, Helen. On average, a matter before the tribunal could take anything between 6 and 12 months. However, a lot of matters get delayed, not because of the tribunal, but by counsels themselves and their clients. So we have had many cases, or the cases before the tribunal. We have encouraged the applicants or the appellants to settle their matters amicably with the authority. And we are glad to say that in matters before the tribunal, 70% of the cases have been resolved amicably between the appellants and the tribunal, leading to a very quick turnaround in dispute resolution. So for those who insist on going on full hearing, I would estimate that 12 months would be an average timeline, keeping all factors constant, and not delays arising from counsels.
Thank you, Mr. Ogola. Professor Moura, TLAB, on average, how long would we expect a matter to take?
Thank you. I think I'll talk about it in terms of just two categories of cases. Some of them take very, very, very short time, and others take a bit longer. And the categories I'm talking about, the first category is probably the very straightforward cases where someone is complaining about the fact that NTSA has failed to act on the application for a license. Those are usually very, very straightforward. Or someone is complaining and saying, a SACCO woke up one morning and they found their portal closed, and the portal was closed without a notice, without a hearing, without being given reasons as to why they should, the portal should be closed. Those are also very straightforward, because in most cases, we find that either NTSA has a reason or no reason. If they don't have a reason, they lose the case. So those kind of cases, we actually able to finish them even within a week. Some of them even within 2 days. We hear the case today, by tomorrow the judgment is ready. Those very straightforward cases. The other cases which are a bit more complicated are the ones where one SACCO is complaining about the licensing of a live SACCO, where it was licensed without having met all the conditions. They are required to have at least 30 vehicles to be licensed. So sometimes you can find the SACCO has been licensed with only 10 vehicles. And the person who is complaining is actually complaining because there's collusion between NTSA and the new operator. Those kind of cases, they might take a bit long because sometimes you find that NTSA has to come to court. They have to produce all the documents showing whether the SACCO had actually complied with the regulations, producing all the licenses, road service licenses that they had given to the vehicles, and proving that these vehicles belong to this SACCO. So those ones might take like 3 months. But in most cases, our cases are done within 3 months, we are finished, even in those long ones. Thank you.
Wow, 2 days.
Oh, yeah.
Wow, that's amazing for the Kenyan judicial system. Dr. Gishuki, on average,
Yes.
how long would it take us at the Civil Aviation Tribunal?
Thank you. I'm not even sure that I can be able to give an average, for the simple reason that I know all my matters offhand. We have very few matters at the tribunal. So I might actually even start saying which one has taken how long. But generally, we can talk about between 6 months and 12 months. The reason being that some of them are quite complicated matters that would require, of course, the calling of witnesses and so on, which of course takes some time. But 6 months, some we conclude within 6 months. Others, of course, would take longer, but those are the ones that that require a lot of, let's say, witnesses and a lot of work into going into them. So within a year, I think we are able to finalize on all matters, and that is how come we have very few matters that are pending. Indeed, we have at the moment, for example, less than 10 matters at the tribunal, and therefore we can be able to finalize them as soon as parties are ready to proceed with them.
Thank you, Daktari. I think it's also because we didn't know we can't do airlines. Now we know. And back to you, Daktari. The next favorite question that Kenyans like to ask after how long is how much? What is the average cost of a matter at the Civil Aviation Tribunal?
Thank you. Thank you. I'm not sure that I should actually say this. And what I mean is this, that for the matters that we have at the tribunal, we haven't charged filing fees at all. And the reason has been that we haven't had regulations and rules to govern that. And therefore, it's only now that the new fees have been gazetted and they are operational, that we are now actually going to use the schedule of fees that has been gazetted for tribunals. But before then, because there was none, actually all filing for all the cases that we have at the tribunal has been free of charge. Yeah, so we haven't been charging, yes.
Thank you, Daktari. So the takeaway for me from this is to file as soon as possible before you start implementing the new gazetted charges.
That may be so, yes.
Thank you. Professor Maura, on average, how much would it cost someone?
Yes, for us at the Transport Licensing Appeals Board, we will charge a minimum fee, one-off fee of 1,500. That's all that you need to pay for the filing fees. Very, very affordable, because we want to promote access to justice.
Indeed. Dr. Ogola, sorry, Mr. Ogola.
Yeah, in the tribunal, according to the rules of procedure, we have these majorly being commercial disputes. There is a fee of 5,000, which is an administrative fee. And then when you file an appeal, it is 1% of the value of the subject matter. If, for example, the authority has fined you 100,000 shillings, then 1% of 100,000 will be 1,000 shillings, which you will pay as the filing fees. Where the subject matter cannot be determined by figures, then the filing fees is 50,000. And where we have figures in terms of, say, you have a fine, the minimum should not go below 70,000.
Okay, thank you very much, Mr. Ogola. I want to go back to Daktari, Dr. Gishuki. This question is to you specifically because I don't think the other two tribunals have monetary awards. By any chance, does your tribunal give monetary awards? I'm asking this for a fellow lawyer. I know they are interested in knowing that.
Yes, indeed. The jurisdiction we have involves awarding monetary awards, and therefore, and for just as an example, if you paid so much, or you are to an airline and you feel that you didn't get what you wanted, you can come to us for both, for example, the refund and damages, and therefore the tribunal can award that. So we have that power to award monetary awards.
Right, thank you very much. Participants, for those who are joining us, welcome. Please remember to use the chat section for your questions. We'll soon be addressing them in the Q&A session. My next round of questions I'll start with Mr. Ogola. I think you have already hinted at this, but just to clarify for our participants, are there any rules of procedure, or are you free to use whatever you want? Civil procedure, are you bound by those?
The tribunal has rules of procedure, which were gazetted under Legal Notice 108 of 2017. The rules basically guide the tribunal how they operate. As you may be aware, the tribunal came into being in 2010, when the Constitution of Kenya 2010 was also passed. We are also guided by the principles set out in Article 159, which basically give direction as to how the tribunal should handle its matters, encouraging alternative dispute settlement, justice to all, and all the other principles of justice which are set out in Article 159. Our rules are quite flexible, and as a tribunal, we try to make the processes very simple for the parties. We encourage counsels to communicate with our secretariat from time to time. This being a gray area of practice of law for many practitioners, we try to make it very simple for practitioners. We do not dismiss matters. We ask counsels to look at the rules of procedure and familiarize with them, so that it makes matters very easy for both the practitioners and members who sit in the tribunal. Thank you.
Thank you, Mr. Ogola. I think Dr. Gishuki had already said that they are awaiting regulations. Is that correct? The gazettement of regulations?
Yes, we are working on them actually we haven't taken them through public participation, so they are still way off. But we are working on them now. Actually, were it not for this COVID situation, we would have finished and taken them out. But we are working on them perhaps in another 2 or 3 months.
Okay, thank you, Daktari. As for Professor, from what I understood, yours has no technicalities at all. I can just walk in and...
Yeah, you're right, because what happens is that the statute that is created, the Transport Licensing Appeals Board, gives us the option of either having the regulations, rules of procedure, or just setting our own procedure and proceedings. So when we looked at it, we decided that because the cases that we handle are very diverse, that we shall handle each case the way it comes. So we have our own procedures and proceedings, and there are no very restricted procedures that are there. Although we have drafted something, 1 year ago, we have a draft of some regulations, but we appear to be operating quite well even without the regulations, and we might actually not even go for the gazettement of those rules of procedure.
Thank you, Professor. And now that I have you on the floor, Professor, tell us, where can we find your tribunal?
We are located at the Transcom House at Upper Hill Community near the Milimani Law Court, where you have the bus stop of KBS. Just the building next to that bus stop is the Transcom House. We are there on 2nd floor, and we also travel around. Even we move around to hear cases. If cases are in Mombasa, Nakuru, Thank you.
So I can simply alight from the bus and go to 2nd floor and report, right?
You're right.
If I may request you, Professor, to just type out your email address on the chat section for the tribunal in case we have members of the public who'd like to contact you. In terms of filing or hearing of matters, Do I have to appear physically, Professor, or have you embraced virtual courts?
For the moment, we tried the virtual system, but we find that most of the people who use our court, the court users, as we said in the beginning, they tend to come very much from the informal sector of the transport. And so they were having a lot of challenges in terms of having gadgets that can allow them to join online meetings. So for now, we still do the physical meetings.
Asante sana, Professor. Mr. Ogola, you told us we can find you at Kenya Reed Towers, 10th floor. Can we reach you on email?
Yes, you can reach me on email.
If you do not mind, perhaps you can share with us the email address for the tribunal in the chat section.
Okay.
Thank you very much. Dr. Gishuki, where can we find this tribunal where we can sue airlines for missed flights?
Yes, we are situated also at Transcom House, still the one on at Community. We are on 3rd floor. And therefore, filing for the complaints and appeals can either be done physically, Transcom House 3rd floor, or on email. So meaning that a person can just send an email with the pleadings or the complaint, and then it will be deemed as filed.
Are your proceedings virtual or physical?
Yes, our proceedings are virtual, but in 1 or 2 instances where there is need to have a physical hearing, we organize that and we do it physically, especially when we are taking some special evidence, but we are doing them virtually for now.
Thank you. I forgot to ask you, Mr. Ogola, are your proceedings virtual or physical?
Thank you, Helen. We have adopted virtual sessions for most of our hearings due to the difficulties of COVID protocols. We encourage parties to file both all their matters virtually and in hard copies. We hear counsels through virtual sittings. And in certain instances where the tribunal has to record evidence of the parties before it, then we've had sittings outside the tribunal. We've had sittings in the Mombasa during a case involving the Mombasa tea auction. We've had sittings in Kericho involving matters relating to the tea sector. So as and when there is need to take evidence outside the courts, then the tribunal will be able to sit outside the courts. But for most applications and administrative things, mentions, giving directions, we do the matters virtually.
Thank you very much. Now I'm going to ask one final question before we go to the chat section to look at the questions by participants. Participants, kindly remember to type out your questions in the chat section. We're soon going to have the Q&A session. And there is also a poll on your screens. We would appreciate your feedback by filling in the poll. Thank you. So my final question to our panelists this afternoon. Dr. Gishuki, let me start with you. Just give us 2 reasons why should we file a matter with your tribunal as opposed to going to court, high court. Why should we come to your tribunal? Just 2 reasons.
Thank you. First thing I would say is that, as you had mentioned earlier, this tribunal isn't really well known. And that's why most people have not been coming to the tribunals or to this tribunal. But number one, we say that, of course, the issue of time, the time within which we conclude matters, it's quite fast. Of course, it can be compared with the mainstream court system. Number two, of course, we have what we call specialized way of doing things because of the experts that we have. Because we have representatives from the airline industry, persons who have been involved in airline matters. Of course, we also have someone who is appointed to represent the public, and therefore public interest is is well taken care of. Of course, thirdly, we say that the law requires that on matters that the tribunal has jurisdiction, then you go to the tribunal. Indeed, what we have done is that there are quite a number of matters that were previously filed in several courts around the country. And when now we started the operations, we actually sensitized the courts, whereby now the courts now send them to us so that we can hear and conclude on them. Thank you.
Thank you, Daktari. Mr. Ogola, 2 reasons why we should come to your tribunal and not commercial division.
Thank you, Helen. Actually, I only have 1 reason. And that is because the law requires that if you're aggrieved against the decision of the competition authority, then you have to come to the tribunal as the court of appeal of the first instance. And for people who may not know, who are tuned in, you cannot run to an upper court when the law provides for an avenue of getting redress. And that is why the only reason why you have to come to the tribunal, because the law says so. So in matters, you may have a matter relating to competition authority and you run to the High Court. The High Court will refer you back to the tribunal because the law stipulates that where there's an avenue for dispute resolution, then you have to start with the dispute resolution mechanism provided for under the law. So that's the only reason.
Thank you, Mr. Ogola. Finally, Professor, 2 reasons why I should come to TLAB.
Yeah, just 2 reasons. Is one of them is about the quick, very efficient services that you're going to get. As I said, in some straightforward cases, within a day or 2 days, you actually get a final decision of the tribunal. So it's that efficient, and I think I would say that's one of the reasons why people should come to the Transport Licensing Appeals Board. And the other one is also with the fact that we are quite flexible. We are not tied by those technicalities of the regulations, and we try to accommodate as many people as we can. So you'll find the procedures to be very formal and very easy to deal with. The other one is also to do with the cost. As I said, the filing fee is only 1,500. So there's no other charge that the litigant are going to be asked to pay to the Transport Licensing Appeals Board. Thank you.
Great, thank you very much, gentlemen. So participants, you've heard it from them this afternoon. We have been told that the Competition Tribunal sits at Kenya Re Towers, 10th floor. Feel free to visit them, find out more about what they do. Conveniently, we have 2 tribunals at Transcom. So when you alight from the bus or your shuttle at Community, just jump up to Transcom 2nd floor and you'll get your TLAB. And then you go up just 1 flight of stairs and you are at the National Civil Aviation Administrative Review Tribunal. Quite a mouthful. So now I want us to go into the Q&A session, and I will be dealing with the questions that are in the chat section. Question number 1 goes to you, Dr. Gishuki, which is, can members of the public aggrieved by a decision of KAA appeal to this tribunal?
Now, let me assume that Susan meant KCAA, because we do not deal with decisions from the Kenya Airports Authority, so it is KCAA. Now, when I mean the jurisdiction of the tribunal kicks in when KCAA makes a decision, or even does something or makes an order of some sort, and it's unlikely that a member of the public will be affected by that decision unless he is a licensee or he proposes to perhaps get some license. And therefore, yes, he can if he is a licensee of the KCAA, because it is more or less about someone who is supposed to do something under the Civil Aviation Act, but KCAA fails or declines to give a license or to authorize and so on. So someone can come to court. So it is about the matters that are provided for under the Civil Aviation Act that KCA has dealt with or failed to deal with. So it is possible, depending on what it is.
Thank you, Daktari. Second question is still to you. Can one sue a travel agency where tickets were procured through the travel agency?
Yes, indeed, on the consumer protection matters or jurisdiction of the tribunal, one can sue the travel agency if it is a travel agency that was involved in the procuring of the particular ticket. And this consumer protection, and just to expound just a little bit, is it's quite wide, because it is anything that a consumer of air transport services feels that he didn't get, let's say, value for money, or he wasn't treated well. And this, for example, includes things such as even a deceptive airline advertising, for example. That is, if one airline is saying that we charge less than the other, but then it isn't so when you go to pay, for example. So even such things actually come to us. So a person can sue a travel agency or the airline in all those instances.
Asante sana. Then we have a question to Professor. Are the decisions rendered by the tribunal final, or is there an appeal mechanism?
Yes, there is an appeals mechanism, because we find the law that is creating the tribunal appears to be silent, is silent on that issue. So it doesn't say that the decision is final. So when it is silent, that anyone who is aggrieved, they can actually go to the High Court and appeal against our decision.
Asante sana. Then we have a final question to Dr. Njaramba. Can your tribunal intervene where there's a deadlock between an aviation company, I think two equal parties, something like that, where there's a deadlock? I don't know if that is part of your mandate.
Yeah, I'm not sure what Joanne means, but where it isn't about a consumer and an airline, or between the airline and KCAA, then you wouldn't have jurisdiction. Because if, for example, the way I see the question, if for example, it is about the ownership of a company, then now that goes to the ordinary courts. So if it isn't within the mandate, within the Civil Aviation Act, then we may not have jurisdiction to deal with that.
Thank you very much. So, ladies and gentlemen, I don't see any other questions for our panelists this afternoon. Allow me to thank our panelists this afternoon. That is Dr. Njaramba Gishuki, Professor Kiare Mora, and Mr. Daniel Ogolla for making time to inform us, enlighten us about their very interesting tribunals. Speaking for myself, I have now learned that I can actually sue an airline if I do not fly. It was very interesting. And also that I can sue NTSA if they delay with my driver's license. I am quite enlightened this afternoon. I'm not sure what case I can bring to Mr. Ogolla's tribunal, but I'm sure I'll look for one. So ladies and gentlemen, you've heard it from them. Why should you file a case before these tribunals? One, it is faster, it is simpler, it is less rigid, it is cheaper. These are new areas of practice for the lawyers who are looking for something different to do. It is specialized. You're not just dealing with one person, you're dealing with several people with expertise in the area. And if you did not see it from the faces of the three gentlemen today, I can assure you that the tribunals are a lot friendlier. So with that, ladies and gentlemen, I want to thank you very, very much for making time this very cold afternoon to listen to our panelists. And I will invite you to our last session, which will be next Friday, where we will be addressing other tribunals. So thank you very much, Dr. Gishuki, Mr. Ogolla, and Professor Mwaura for your time and for sharing your knowledge and telling us a lot about your tribunals. And we look forward to seeing the rest of you next week on Friday. With that, from the LSK Nairobi branch, it is Asanteni Sana, and do have yourselves a wonderful evening.
Thank you.